Welcome to Arjun Bhagat Decodes. Today we are speaking to Vikas Singh, one of India's finest legal minds. Vikas is a senior advocate in the Supreme Court. He's also been president of the Supreme Court Bar Association for 3 years, for 3 terms. You've also had a lot of run-ins with judges, more recently with the Chief Justice of the Supreme Court, Vikas. So you really don't hold back, do you?
So firstly, I'm a first generation lawyer. So I have not been, nobody has propped me up in this profession. I didn't have a godfather in the profession, so to say. So that is why I somehow feel that I have, I have more internal strength to be what I am, apart from the fact that this is my nature and this is from my childhood used to be like that. But most of my run-ins, whether it be the recent one with Chief Justice of India or even the earlier ones, are basically principled ones. So I just, when the Chief Justice's issue, this bar was wanting this land where we wanted chambers to be constructed, and he was not hearing my matter. We got listed. It used to get listed, not taken up. It used to be mentioned, not listed. So this happened about 10, 12 times. So I realized that there is something amiss. So I went and talked to another judge of the Supreme Court. He said there is something in the Chief Justice's mind. Probably he wants to do something else on that land. And then I realized that I must escalate it. So the issue was only that either you hear it or give me a sure shot hearing or put it as item number 1. And he was not agreeing for that. So I said, if you don't give me a date, I'll have to come to your residence. And he flared up on that. So there was nothing for him to flare up on. I said, every litigant has a definitely a right to be asking for a hearing, and the Supreme Court Bar Association, if it can't get a hearing, it's very sad. So that's why then I had to call the general body meeting. Then he immediately called for a hearing of a special bench, and then he passed that order. For the first time in the history of Supreme Court, by a judicial order, it was said that the Supreme Court Bar has to be consulted every time some infrastructure development takes place. So it's basically always a principled issue, like the earlier ones also. If you want me to talk about them, I can also explain.
Now that a lot of the legal cases are actually live, we're seeing the justices, talking to the lawyers, and it's out there in the open. One of the things that I have noticed, and actually a lot of people have been commenting about this aspect, is, we all respect the judges. After all, they are dispensing justice. But there seems to be, and I have felt this, that the judges, many of them, not all of them, demand subservience from the lawyers and also the litigants.
So according to me, this is definitely not a congenial atmosphere for the justice delivery to happen. So whenever you see the Supreme Court overstepping its jurisdiction, invariably it happens because there is nobody there to point out to them that, look here, this is not your domain. There is a concept of separation of power, which is a basic feature of our constitution, and you are getting into an executive domain exclusively, and which you should not. Now, if you look at the history of this court, whenever they have been asked to define what is the judiciary's power or the executive power, they've always done it correctly. It's only when they start hearing a PIL, or if they start, deciding something which is to do with the executive, they sway and nobody tells them. And I feel that this atmosphere of, expecting that kind of subservience from the lawyers is not correct at all, because it ultimately...
So you agree it does happen?
It does happen, and it is something very wrong for the institution, I feel.
Right. So you talked about, the Supreme Court taking in PIL cases and also taking suo motu action in a number of, and which is the prerogative of the Supreme Court. I have figures in front of me. Of course, I was going to come to those later, but I think this is the right time to talk about them. The Supreme Court has some 80,000 plus cases which are pending. We have a bench strength of 34 Supreme Court judges. I think we have 33 right now. How does the Supreme Court dispense justice to 80,000 plus pending cases?
So it's a twofold, I would say, problem as far as this disposal is concerned. Firstly, as you earlier pointed out about the PI jurisdiction, a lot of the time of the court is being taken up by the PI jurisdiction. So the PI jurisdiction is not the jurisdiction for which you were created. I'm not saying that you're not doing some of the PI work that they've done is also exemplary. But the way it is being taken up at the cost of regular litigation piling up is not something which is acceptable. If tomorrow, supposing the executive were to say that since you are not able to decide these matters now, all the 5-year-old matters we'll decide, that will be a breach of separation of powers. But nevertheless, the executive will be justified that you are not able to decide it yourself. Like what they do for the executive, they say you are not deciding this, or you're not taking this difficult decision, so we'll take that decision. That is where the fallacy happens. Second is, of course, the I would say the lack of decisive judges. I mean, a lot of our judges are very good. You may be a brilliant judge, but if you're not decisive, you really doesn't keep the wheels of justice moving at the pace at which we expect it to do. I remember a long time back I had appeared before Justice Irani in the National Consumer Forum. I was, I think, 1 or 2 years in practice, and it was an appeal. And when I stood up, he asked me to sit down. And he read the file, and he asked the other side, what's your answer? They didn't have an answer. And he started dictating the order, heard both sides at great length, and he dictated a full-fledged order. And it was a perfect order. So, not that it went in my favor, it could have gone against me also. So, what I feel that if the judge is, if he reads the brief comment and if he is decisive, disposal can be much faster. So, there is somewhere, I would say, the lack of the initiative to get the right people to the institution. And that is true for the High Courts and Supreme Court both. So you have to get people who are decisive and who are able to, take a call immediately rather than hear a matter for hours and days together. So there I feel the quality of judges, of course, needs a relook. And also the infrastructure many a times, especially when the government is the litigant, you will find government never files its replies on time, and they keep taking time, and even when the matter is finally called out, they are not well prepared. So that is the other part, where you will find government litigation mainly, and even some private litigants also are still in the adjournment culture, and they feel that adjournment is a matter of right.
I wanted to, talk to you about the Kolkata rape case. Of course, the Supreme Court has been hearing, this case on a regular basis, and it's also live. The Chief Minister, Mamata Banerjee, has been calling for stricter, more stringent laws for rape and for murder, and I think the legislative has passed, the State Assembly has passed some new laws. Is this all political posturing? Because as far as I know, we already have very stringent laws in place. What we may be lacking is, collection of evidence or then properly filing it. Is it political posturing?
So, according to me, it's a knee-jerk reaction. And when Nirvaya happened, they amended the Indian Penal Code drastically and made, rape more, I would say, an offense which could be very easily established without much evidence, the way it has now been drafted. But I'll tell you something very interesting which I have dealt with in my career. So there was this judge in a small place called Araria. Judge's name, I remember I had also represented him, Shashikant Rai. So he had a case of a child, 6-year-old Dalit girl, brutally raped. And the only mistake that he did was that when the girl's side of testimony was there in court, he heard all of them the same day, because he realized, and this is true for all rape cases in the country, and today you will see how there is a hue and cry of speedy trial, etc. Everybody is talking. So what he did was that he heard all the evidences on the same day and asked the other side to bring their evidences the next day. And since they didn't have any evidence to give, so he heard the argument and decided in a couple of days. He was suspended for that. Okay. I had to file a case in Supreme Court and a writ petition to get his suspension withdrawn. And that judgment was set aside by the High Court only on the ground that he gave speedy justice. And that was affirmed by the Supreme Court. And I tell you, this kind of justice which he gave is actually the need of the hour. Because what happens in these rape cases is it's the height of travesty, I would say. So Supreme Court also, said that no, you can't do this. You have to give time. When you and this is a mind your child victim.
60.
POSCO is a victim-centric legislation.
Right.
A victim-centric legislation. Of course, when you have the a doctor involved and a major doctor and who's killed also is also equally heinous. I'm not saying that it is no less. But then this particular case grabbed the media attention. That particular case didn't grab the media attention.
But that's true of a lot of rape cases, where, I mean, the latest statistics are of 2023 December are that India has nearly 30,000 plus rape cases which are registered. Now, if you really look at that, I think that's not even a fraction of the ones that actually take place. Like, for instance, I'll give you in the US, every year about 450,000 or 450,000 cases are filed of rapes and sexual assaults. Yeah.
So that is where our policing is, needs to be completely reformed. And I've done another case of Rajasthan where again a child victim, her FIR was not registered at all, and it was only when the judge really intervened, and it was again a very bright judge who intervened, and he also had to face trouble for that. He had to face strictures by the High Court, and ultimately I got those strictures, from the Supreme Court removed against him. But his only grievance was that the police has not done their duty, and the police lobby is so strong that the High Court was in his favor. So ultimately, even this statistics that you have, hardly 10% or 20% actually get into conviction or get into proper trial.
It's 27%.
That would be trial. The conviction would be even less than 10%. So the policing in India for a rape victim to go and get a case registered is a trauma by itself.
Right.
And you have said that there should be a video installed, video recording of when the victim goes to the police station. But it is all more in breach than in observance. The kind of questions the Thana will ask a victim when she comes to get the FIR register is something which shudders any girl from a good family to even visit a Thana, because she knows that she'll have to go through that trauma. So that is where we need to be. That's a completely different aspect in this country,
right,
where police has to be completely taken out of the control of the executive. And for that also there is a judgment of the Supreme Court, Prakash Singh's case.
Yes, of course.
And even till date, no government, whether it be BJP, Congress, or
Nobody
Mamta,
wants to act.
Nobody wants to give up the control on the police. So that's the other, that's the executive side problem in these kind of cases. But it's a very sad state of affairs.
As a senior advocate, you talked about two cases of minors that you have experienced yourself and how difficult it is. I mean, here, one case where the judge passed the judgment but was removed, as in he was suspended, and the other case where the High Court passed strictures. So what is it? Is it, is it socio-economic, or is it, just the mindset in India? What is it? What are we lacking? And here we are not talking about, the general public at large. We are talking about learned justices.
So basically, there is something I would say in our, and when I say our, I don't mean mine or yours. I mean the average mind's, thinking, and they still, a large part of our society considers women as barely an object and not as a human being, and they feel that. So that is more of a social issue in this country than a legal issue. And because it's a social issue, our judges are also from the same society. So, the mindset percolates down.
The judges, the police,
the lawyers,
doctors who also do the post-mortem.
Everybody.
And that in itself is another story where, as a reporter, and I have covered some rape cases, murder cases. I mean, even to get a post-mortem report and the correct post-mortem report, they're completely different stories. We don't even have the scope of getting into that particular discourse. Let's talk about the 3 criminal laws which have now come into being. They have been enacted by the government of India. The legislation was passed in December 2023. From your perspective, what are the main features of that stand out?
So the intent definitely is to do reforms, and there has been quite many reforms in the three laws. But again, in my view, and that's my very personal view, these laws have been rushed in, and for our the system, so to say, whether it be policing, prosecutors, and the defense counsel, the judges, to be sort of conversant with this law will take a long time. And that is why it was necessary that this should have been gone into very slowly with a elaborate and detailed stakeholder consultation by involving the bar, the judges, the prosecutors.
But now that it has been pushed through, and one keeps hearing that there are seminars being held for the judges, for the police, there are workshops happening. So we clearly, as a society, not really ready for these laws right now. But do you think they're going to bring in more transparency, modernize the way the criminal justice system works?
There are two sides of this, So according to me, as far as the freedom of speech is concerned, according to me, the new laws are against, they're anti-freedom of speech. And
can you be a little more specific?
So there are laws, which where the prosecution or the police has the liberty to rate any speech as anti-national, and which used to be, if you remember, in the earlier laws, it used to be that sedition, etc.,
Right,
which Supreme Court had said that sedition will not be brought in unless there is an incitement to violence.
Right.
So the section didn't say so, but the Supreme Court had said so, but still it was not being followed, and the judgment of the Supreme Court was not part of the letter of law. So the Thanas are still, implementing the law, because the law was a little unclear on that. And if you recall, I defended Vinod Dua. He had to face a criminal case in Shimla.
Right.
In his last days, where he was hauled up only because he said something in one of his, interviews or whatever he used to do. He used to do more of a private, this kind of a telecast. He had some running show in which he used to talk. And for that, he was hauled up, and I had to get a judgment from the Supreme Court. I had to get the whole thing straight from Supreme Court and ultimately get a judgment where they said that this is part of his free speech. Now that, according to me, is now a discretion with the police. I don't remember the exact section because I have not read it recently, but I have given an interview earlier on this.
So what you're saying is the police has now more power.
More powers to rate anybody's speech as anti-national and volume up, without that safeguard of inciting to violence,
Right.
which should have been there, should have been incorporated in this section. But there are a lot of good things also. I'll not say that the timelines have been made streamlined, and there are a lot of benefits even to the, I would say, criminal justice delivery, because of the earlier lack of timelines, things used to go indefinitely on for a long period of time. So there are good things and there are bad things. But one thing which I found, according to me, is also very highly objectionable is the naming of the law in Hindi.
Right.
Because our constitution says that all parliamentary legislation have to be in English.
Right.
And although I'm from a Hindi speaking area, for me also to decide at first blush which one is the IPC and which one is the CRPC,
Right.
takes a little bit of time. So I can imagine the plight of somebody in the south or in a non-Hindi speaking state to understand the meaning of the three enactments.
Yeah.
So that should have been in English.
So you talked about, pendency of court cases. We talked about that a little bit. I just want to go over some of the figures that we have. We've got over 82,000 cases in the Supreme Court. We've got over 58 lakh cases in the high courts. And we have a staggering 4.5 crore cases in the district and the taluk courts of India. It's great for lawyers and law firms, but how do you even dispense justice? How do you keep faith in the judiciary with this kind of pendency of cases? And I mean, many of the cases are not going to be solved for years and years to come. And you have more cases. So you have legacy cases, and then you have new cases which are being added by the day.
So, firstly, Arjun, I feel that it's not to the benefit of a lawyer if this pendency goes up. It's always to the benefit of a lawyer if disposal happens, because more people will have faith in the justice delivery. And because of this pendency and because of the delay, a lot of people don't come to the justice delivery at all. They look at alternative means to sort out their problems rather than coming to a court. So it doesn't really subserve the interests of the lawyers. But as far as the pendency is concerned, I would rate the lower court problem to be different from the High Court and Supreme Court. Lower court, invariably, it is lack of infrastructure. And I have seen or I have heard of courts, which don't have the paper on which the order is to be written. So you have to get that paper from outside. I have myself appeared recently in a cross-examination of my personal case in the trial court, probate case, where the judge said that there is only one stenographer and he'll have to go to very soon to the other court. So please do it in the morning. If you can't do it, then I'll have to postpone it to some other day. But fortunately for me, he could do it before in the first half itself, and it did happen. But if the stenographer is not there for the whole day, you can imagine the plight of the judge. He is limited by this infrastructure issue of being able to... then there are vacancies in the lower courts which are not filled up in time. So these are very serious issues as far as the lower judiciary is concerned. As far as the higher judiciary is concerned, I think as far as the high courts, there is a very major issue of, again, appointment of judges. At any point of time, if you see the strength of the high courts in the country, you will find more than 1/3 of the vacancies of the high courts unfilled, any point of time. So that's something which is, nobody can justify, because you've taken this.
That's a tussle which is constantly on forever between the judiciary and the executive.
No, this is not a tussle. This is a problem within the judiciary. Tussle will happen if you make the recommendation and the appointments don't go through.
Right.
That is the tussle part. But here you don't even make the recommendation. Out of those 1/3, you will find at least 80% of those would be of cases where you have not even made a recommendation. How do you justify that? Your own judgment says that a vacancy is happening on a particular day. You should start filling up even 6 months in advance. So what to do of trying to fill in advance? You're not even making recommendations.
So you're saying a large part of the fault lies with the judiciary.
With the judiciary itself, of not being able to recommend people. Now, why are they not able to recommend people? Because there is no mechanism in place to identify the right people. This is all, according to me, this is all by, word of mouth. Collegium judges, whom they know, whom they see.
That's true for senior advocates in the Supreme Court as well, right?
No, senior advocates is a different story. I'll come to that.
It is a different story.
It's a completely different story. So, if the judges are going by, whom they know and whom they see, if they are not, supposing if the Chief Justice of the High Court doesn't hear criminal matters ever, so that means no criminal lawyer should be appointed to the High Court. So it's a very, very, I would say, they need to reinvent themselves. They need to really work on this system of trying to find the right people. I say, why not people from the law firms? Now you've just appointed 2 lawyers from law firms to the Delhi High Court. But this is not happening otherwise. Law firms, from people who are not coming to the higher courts or working in trial courts, why can't they be considered for appointment? But who's looking at those kind of people?
Right. So recently, the Chief Justice of India endorsed the idea of a national level recruitment process for the judicial services judicial services for all states on a national basis. Now, he said that the time has come to think of national integration by having recruitment to judicial services which crosses, and I'm quoting him, narrow domestic walls of regionalism and state-centered selections. So I have 2 questions in this regard. One is this a good idea? And second, and to the point that you made about the higher judiciary, shouldn't something like that then be in place for the higher judiciary to make sure that the vacancies are filled up in time, so that the selection process is more fair rather than an ad hoc kind of thing? And then Of course, the judiciary in India, I mean, the legal practices, judiciary in India is changing. As you said, why don't you get more people from law firms? You have so many young, dynamic individuals. Then there is this question of women judges. And that's something you have pointed out. We barely have 13%, 10 to 13% in the high courts of India. We have 788 judges, out of which about 105 or 7 are women. So we've got a number of these, different questions.
So, Arjun, I'll take the last thing first because that's something which I've been, working on for quite some time. So, when we talk of women judges, you see in the lower judiciary, where the appointment is purely merit-based. And when I say merit-based means there is an exam and there is an interview, and on that basis you select people. So, anybody has a choice of applying and being considered for that appointment. So, in a merit-based selection, we have more than 33% women in the lower judiciary. In the higher judiciary, which is not merit-based, you have this percentage of 13%. And Supreme Court is now less than 10%. It's about 8% down. We have only 2 more remaining now. So one Justice Seema Kohli just retired. So there is definitely a lack of the will to appoint women, to the higher judiciary. So when whenever it is talked to these people, they always retort by saying that you people are not engaging, women in your offices. That's not the point at all. The women are there in the system. They may not be in my office. Although, incidentally, in my office I have, but otherwise they may not be in law offices. But they are there in the system. They are in law firms. And a lot of the women lawyers are doing exceptionally well in law firms. Because, by their very nature, the kind of work that they do in a law firm, because our hours are crazy.
Right.
We can work till midnight or something. 24/7. So law firms is an easier job as far as women are concerned. And we have some brightest minds there. We have women in the lower judiciary. So you are not trying to look at them at all. And because you are not trying to look at them, this is the percentage that you have in the higher judiciary. So you can't say that women in this country don't deserve to be elevated to the higher judiciary, or that you have to wait for them to be picked up by lawyers in their offices and then only they should be brought into the higher judiciary. According to me, I don't agree with that at all, because recently they have justified a lady from a law firm to the Delhi High Court recently. And they have said the same thing, that she's got a good practice, she knows the law, she's a domain expert, she's got a good return of income. And even though she's quite young, they still have recommended her. So if you want to do for a particular individual, you do it. But there is no system to regularly look at similar kind of people. So if this particular girl was known to somebody in the collegium because of which he picked her, well and good. I have nothing against that. I mean, if she deserves it, she definitely needs to be elevated. Yeah. But the system of picking people only whom I know, I have a huge objection.
Right. So you're saying it needs to be institutionalized so that we have proper procedures in place, and also we look at a diverse, range of individuals in various fields of law. Let's come to what the Chief Justice of India said about a national judicial service rather than the state. How does that work?
So as far as the national judicial service is concerned, firstly, that is not in the domain of the Chief Justice of India.
Precisely. So he says the time has come to think about.
So it's a very good thought, no doubt about it, but it has to be by a constitutional amendment.
And that's also, would that be infringing on the state's right?
No, so if it is by a constitutional amendment and if the proper procedure is followed for doing that amendment, it will not infringe any state right, and I think it's a very good thing to happen. And I take this forward to your suggestion that this should also happen for the High Court. Why not? If you are creating a database of lawyers to be picked up for the High Court as well, so what is the criteria? So you have a 45 years as the minimum age. You can specify a particular return income as the criteria. You can also specify a particular number of reported judgments as a criteria. And then today, the way information technology has, pervaded our country, you can pick up those names in the entire country and have all these people who qualify in these 3 aspects. and then try find out the good ones. But that exercise is not done ever. Nobody is interested in doing that exercise. And if you do that exercise, you can also have a similar all India selection for the higher judiciary, like you have for the IAS, and also have outsiders or insiders, and that will provide a very good national integration feel. Like in Supreme Court, we have a very different feel of the judiciary, because we have one judge from Karnataka, the other one Andhra, one from Bihar, very diverse. So that kind of national integration, but that's not so in the high courts. High courts, you will find a judge from outside working in a particular high court as a punishment,
Right.
which is also not correct, because if he's bad in his own parent court, why does the transferring
Some of
court,
them are seen as punishment books.
transferring court, why does the transferring court suffer that kind of a judge? So these are all issues, obviously when you transfer somebody because of a serious issue of corruption, or because you feel that he is not fit to be a judge, or because his temperament is not correct, obviously there was something wrong when he got appointed.
Right.
And that is where you have failed in that sense.
So we are seeing a new age as far as courts are concerned. We are seeing the Chief Justice of India and the other justices live on TV. Is this here to stay, this culture of live TV, or is there going to be some sort of a pushback?
So as far as this virtual hearing, so to say, is concerned, according to me, it was brought in because of the pandemic. So it was really thrust upon us. We had no option. We had to,
But that time it wasn't live for the larger audience.
it was live in the sense that it was virtual, so client also could access and it could see. Now they're doing a YouTube telecast, which is recent.
Right.
Where it is telecast, anybody can just log in and see. But otherwise, then also media could see, clients could see. So it was thrust upon us. According to me, the present Chief Justice is, advocating this very strongly, but there will be a course correction in the days to come, especially when he retires, because I sense amongst the judges that this virtual thing should not be given as a matter of right to everybody, because the whole purpose of having an institution and having a bar association, all that will completely not be. So you'll have judges sitting at their homes, one judge sitting at his home, the other sitting at his home, lawyer sitting at his office, and so the purpose of having a Supreme Court of India, a huge building like a Supreme Court of India or a Chief Justice's Court, all that will really fade into insignificance. So that should not happen in my view. It should be need-based.
So what about the argument that this will lead to more transparency, speedy justice?
So I'm coming to that. So the YouTube telecast, where a layman can watch the proceeding, is probably here to stay. That will happen, and that's something very good. It should happen, because
All courts.
in all courts, it should happen slowly. I mean, technology will be requiring a lot of technological changes for it to happen in the entire country. Even today, for Supreme Court, it doesn't happen in all hearings. Suddenly, you'll find a link of the Calcutta hearing being circulated by the registry for YouTube. But otherwise, it's not that every hearing is on YouTube. So when the Chief Justice wants a particular hearing to be a sort of live telecast, it is being done. But I feel that should happen as a matter of course, for two reasons. Firstly, for the integrity of the institution, because what happens inside court, people don't know what is happening inside court, and many a times they only read the order, but they don't see what exactly transpired for the matter resulting in that particular order. And it can be very important sometimes. In fact, it also reflects on the justice delivery. It's also important for the litigants, because if the lawyer needs to go to court, or a judge needs to go to court, is very different from a litigant going to court. Why should a litigant be asked to come to court if he can see the proceedings at his home? So this, according to me, that part should stay, but this virtual hearing probably will have to be cut down a little bit. Although as a senior advocate, it will be to my disadvantage, because here I'm sitting here, I can access any court in the country, but I don't think it's something which is desirable for the institution in the long run.
So let me move to our last two questions. Something that you strongly feel about, you've talked about, and you said, and I'm quoting you, people in jails cannot vote, but can contest and win elections. And you've also said the makers of the Constitution would have never thought that such people would be elected to Parliament. A constitutional amendment is needed to specify the charges. Elaborate on this. I think it's a very, very important aspect. We have, people who have cases going on against them. They're in prison. They have been elected to Parliament. We've seen 2 recent cases.
So Arjun, it's a very interesting thing because you can't get selected to the civil services. You can't even become a clerk if you are, in jail, or if you are suffering a sentence. You get dismissed from service if you go to jail for a day, and you can become a legislator. So this has a little bit of a history. So when the Constitution was being drafted, and one of the regrets which Dr. Ambedkar had when he presented the final Constitution was that he didn't provide for any qualification for legislators. And when I say qualification, it means including a disqualification of this kind. But consider the scenario at the time of independence. Most of our freedom fighters had cases against them by the British.
Absolutely.
So obviously they could not have thought of eliminating them from the scope of contest, because it would be doing injustice to the very freedom fighters movement that we had carried on for such a long period of time. But that scenario has completely changed now.
Absolutely.
Today, the people who are, be getting elected are accused of murder, of rape, dacoity, serious offences. And our legislature is not doing anything. I mean, the legislature, it's high time the legislature stepped in. And when you look at the party composition of these criminal background or criminal, people with criminal cases getting to elected, you'll find every political party has them probably in the same percentage. So they are all giving tickets to them. So either you bring in a law to debar them from contesting, and then this anomaly obviously will go, because then you can't vote and you can't get elected, or at least even without an amendment, I would say the major political parties, at least they can take a call that we will not give our tickets to anybody with a political this thing. So neither are they wanting to bring in a law, nor are they wanting to exercise that self-restraint, which they can, which is perfectly within their their right. So this is a huge problem which we have to realize. Now the other problem is that today these legislators are almost more than 40% of our legislature. Very soon, when they become more than 50%, it will not be possible to bring it all up, because they would be they would be the interested parties against that kind of a litigation, that kind of a legislation. So it's actually snowballing into a very, very major issue in this country, and I think we need to really do something very strong. And whenever we ask the Supreme Court to do something, they say, no, this is not our jurisdiction. So they will enter into everywhere which is not their jurisdiction, but not into such major issues where really they'll be doing a great service to what the Constitution was meant to be. And what, in fact, Dr. Ambedkar had said in one of the debates, that our public or our people are so wise that they will ensure that they can select the right people. But his vision in that sense has failed, because he never thought that these kind of people will get elected, because we were in a different kind of a scenario then. We were having people. So he gave an example of when the British arresting some freedom fighters, new fighters coming up and taking their position. So he said, we evolved in such a way that whenever our one person gets arrested, we have somebody new coming up. That is not happening today.
Right.
In politics now, unfortunately, it is becoming, a hunting ground for all these people who have these criminal cases against them. And I have something very interesting to tell you. So when I used to do this Abu Salem case, I was a special prosecutor, and I used to go to TCSRE court. There used to be 30-40 cameras of media cameras coming to cover him. So I have also given a talk in the parliament, and I have also written a piece on this, and in fact drafted a law that people who are in conflict with law, they should not get this kind of publicity. Now, if for lack of evidence, if this person gets acquitted, this publicity will help him to get elected to the parliament.
You're right.
And it's this is again, that's another area where I feel that the parliament needs to step in, and I don't object to media freedom of the press, but freedom of the press does not mean that you have a system where somebody who's in conflict with law is shown more than the ones who are doing good for the country. Where do you see somebody who's done something good for the country being hounded like by the media like this, unless he gets some international prize or something?
Yeah.
So it's a very big measure. The bad smells, the bad news sells. Good news doesn't sell. That's
true. That is true. Even as even as a reporter, we were always told कि यार असली खबर लाओ, and असली खबर का मतलब ये होता था that you have to get news which was to do with crime or with some scandal, and other stuff is not really considered as news. And of course, news has a very short life in India, and that in India and actually around the world, and that kind of worries me about a case even like the horrific rape case in Kolkata, because people forget after some time, so I think somehow we have to keep looking at things again and again. And
so as far as ultimately the rape case is concerned, according to me, the right way forward is, apart from the social change, and we have to teach our children, we teach our boys that they have to respect women, is the speedy justice. If you take these people to trial and do a summary trial in a day and convict them, you see there'll be a difference. When this judge convicted this person in a couple of days, the rapes in Araria went down while he was there. So there was no rape happening because they realized that there is a judge, Otherwise, victims are so many in the country, and they are the most, or rather the least reported. And there is so much of pressure on the family.
Pressure,
stigma, pressure, money power being used. Invariably, the rapist has the kind of money, to buy out the family. The family invariably are very, very poor. And media is also not interested in this kind of a poor family, a poor Dalit family. So the Supreme Court intervenes and says, no, this trial has gone wrong. The whole thing should be redone. And when it is being redone, all the witnesses run away, or they are then won over. So this is what is happening in rape cases. And the real way is to do a speedy trial, according to me.
So in your very long and distinguished career, talk about some of your cases which have stood out, that makes you feel that you've done your bit as far as justice is concerned.
So, Arjun, some of those cases which I feel, I'm not talking of the law that was laid down in that sense, but I've been a strong, proponent of separation of powers. And I remember I was an additional Solicitor General. My office used to be here only in the basement. And the Environment Secretary came and he said that I don't want to appoint the names which the Supreme Court is suggesting to the Forest Advisory Committee. I said, if you don't want it, they'll not be appointed. He said, how? I said, I'll ensure it. So I took all these judgments on separation of power, and it was a bench, if I remember, of Justice Sabharwal, Chief Justice's Court, and Justice Pasayat and Justice Kapadia. And he said, you appoint these names. I said, no, I'm sorry. You can't ask me to appoint a particular name. It's entirely my prerogative. So he said that so many Attorney Generals have come and Solicitor Generals have come and nobody has ever told us that we can't do it, and you are telling us. I said, they may have agreed, but the law has not changed. And I'll show you those judgments. So they realized that ultimately the government had its way. So basically, the problem with our judiciary is, which was actually coming out also of the earlier point that you made of subservient lawyers, is that nobody is ready to stand up for the jurisprudence of this country. Everybody wants you be on the right side of the judge and don't displease the judge, because When I was the additional solicitor general, one of the judge told me that if you annoy the judges like this as an ASG, when you demit office, judges have a huge union, you will not have any practice. I told him immediately, I have not come on the strength of any judge or a lawyer. I'm a first generation lawyer. So if nobody has made my practice, how can anybody destroy my practice? So, but that's the kind of feeling people have. Once I was representing in that BCCI matter, I had some tiff with the Justice Chandrachud and Mukul Rodgi, sort of also on the same side, but he started saying something sort of against me. When the judge rose, he said, "You are talking of somebody who will be Chief Justice for 2 years." I said, "So what? I mean, he's not going to give me anything. I have to do whatever I have on the basis of whatever I know and how I'll represent my client, not on the basis of what he will or anybody will give me." So this is a mindset which needs to change, and I think the institution will suffer a lot if this mindset doesn't change.
We talked about you as a lawyer, the court cases that you've represented. How did you become a lawyer? And I mean, by the looks of it, 9 years you worked as a professional in a completely different field, and then you became a lawyer. Why?
So, I started playing, I mean, we know each other from the tennis court. So,
Right.
I started playing tennis at the age 10, and I had a very dear friend of mine with whom I used to play. So, I had nobody in my family, but his father was the Chief Justice of the Patna High Court.
Right.
So it is only when I used to go to his home and see all the paraphernalia and see how the justice system works that I got motivated that I should become a lawyer. So there was nobody in my family.
It's a brave step to take because, after 9 years, you say, "Yeah, I'm set in my way. I've got a profession. I've got a good job." I think you worked with the Steel Authority of India. It's a government job. It's a BSU job. Why take the risk?
So when I was in my first year of law, this advertisement came for management trainee in the Steel Authority of India Limited. And I didn't even apply for it. One of my friends said that at the age 20, normally you couldn't apply at 20 for any job then. You had to be 21, whether it be IAS or State Bank probationary officer. But this had only 20. So this friend of mine, he said, "I've got 2 forms. Let's apply." So I just applied for the heck of it. Incidentally, that friend of mine, he didn't make it. He later on went to become an IAS officer, and I made it. So I was not keen to join even then. I went there. I didn't like the job. I came back and I started doing my classes. In fact, my father said that you applied for long leave, and so it's a long story. So I ultimately my job continued. They transferred me to Delhi because of a friend of mine. I was studying here, and so when I went into this job, as a 22, 23-year-old, when you start getting a handsome salary, then Steel Authority was paying more than what the IAS was paying.
Right.
So it was, it was a lure in that sense. And you become very powerful. Steel was in short supply. Suddenly people are, around you. So I worked for 9 years. It's only when I was I got transferred to Assam, from there to Calcutta. And my father had then retired. He was living here in Delhi. He had built a small house in East Delhi. So I remember there was a small house in Calcutta, where I used to come from office. Both my sons were on the grill because there was no lawn outside, etc. So I realized that I'm doing injustice to them. And then I, of course, remembered that I had at some point thought of becoming a lawyer. Then I went to Tirupati and I got that inspiration. And then 6 months later, I ultimately resigned and started practicing.
So what message do you have for young lawyers?
So, I say this often when I go to these universities, when I talk to these young children. Everybody feels that what is it which is important for you to become a good lawyer? And according to me, the most important thing for anybody to become a good lawyer is to feel the pain of the client.
So that empathy.
Yeah. So not empathy in that sense. You have to actually get into the shoes of the client. You have to actually understand what is he going through. Then give it a legal shape. Every pain doesn't have a solution. So the pain has to be given a legal shape, for which you require a lot of research. You have to you see whether it is justiciable or not. If a wife is harassing the husband at home, probably it is not justiciable in many ways. It could be justiciable only if they ultimately decide to go for a divorce. But before that, it's not justiciable. You can't ask a court to intervene in somebody's household in that sense. So then you have to give it a justiciable. So that requires that intensive research and the domain expertise of that particular subject on which you are, working on. And lastly, if you are working in the Supreme Court, this domain expertise you have to have on every subject of law. So that is why working in Supreme Court I find is the most difficult, because every time people ask me, should we come directly to Supreme Court? If you are ready to work on, a Transfer of Property Act today and become and take a PhD overnight, and tomorrow work on the CRPC and again take a PhD overnight, and you're ready to burn that kind of midnight oil, Supreme Court, you are most welcome. But if you don't want to do that, and if you're not ready to work that hard, then better to go from the lower court and start with a particular subject, learn that slowly, and then rise in the profession gradually.
So that was, of course, for the lawyers. But as someone looking for a lawyer, an advocate, what should they look? How do I go and look for the right lawyer for a case that I may have?
So this is actually another very unique thing about our profession, that as a lawyer you can't advertise. So we are in fact not allowed to, although now lawyers are having websites, etc., but you're not allowed to have a website also. You don't even have a right to have a board which is bigger than a particular size. So it's a profession which is only word of mouth profession, So I got most of my cases, not because the cases that I won, but more because the cases I refused when I told the client that you don't have a case in the Supreme Court. And I said that, you'll be wasting your money. And somebody else told him to go to court, and he ultimately lost. And then he realized that at least he had given me an honest advice. So it's a word of mouth profession. You have to be sure that the person to whom you're going, and a proper genuine advice in our profession, or I would say even in the medical profession, is at a huge premium. In the sense that very few people are ready to give you a genuine advice considering and understanding your problem. So it has to be, you have to try and find out, by people's experiences, and you just can't get into somebody's office looking at the board and hiring a lawyer. That's the time when
one has to do one's own research, find out about the right person, maybe get an idea about how somebody else's court cases. So
a smart client will talk to a lawyer and realize how much he's in. How desperate is he to take my case, and whether he's ready to give me a genuine advice, even at the cost of whether he may have to refuse the case. So that, of course, that smartness is to be there, but a lot of people don't have that smartness. So you have to ultimately go by that word of mouth of whatever is being spoken about that lawyer in the legal circles, and then take a call.
Well, I think it's great to change the course of one's life when one thinks that you can do better and I think you've contributed significantly. And with that, thank you so much for joining me on Arjun Bhagat Decodes. It's been a great conversation, and it's been a learning for me as well. And we'll see you with another personality, with another topic very soon. Thank you.